Ladies and gentlemen, at this stage of the case, lawyers will be making their final arguments to you. In making these arguments, the attorneys will be commenting upon the testimony you have heard and the evidence that has been presented in this case. Like you, they will be recalling the evidence in the case. They will not intentionally try to mislead you. If your recollection of the evidence differs from what their recollection is, you must follow your recollection. These final arguments by the lawyers are not to be interpreted as evidence by you in this case or instructions on the law. Nevertheless, these arguments are intended to help you properly understand the contentions of each side, and you should give them close attention. Each side will have 25 minutes. Counsel for the plaintiff will reserve 10. Counsel for plaintiff will go first, and he'll speak for 15 minutes, and he'll reserve 10. Then counsel for the defendant can argue for 25 minutes. All right, counsel, you may proceed.
Thank you, Your Honor. You've had a chance to look at the evidence and hear the evidence, and this is our opportunity to try to put it in perspective for you and kind of help you answer some of the questions that the court will have for you in the form of giving you some information about the law so that you can come up with your decision. And the first thing that you'll be given is a statement of the law called a jury instruction. And I hope this is large enough to see, but if not, it basically says Barney Martin was an invitee on the property of Fuel Fitness. You hear people called trespassers, or you hear people called other terms. Invitee is the legal standard that applies here. An occupier of property is liable for injury caused to an invitee by the property's condition only if the owner knew that the condition existed and realized that it created an unreasonable danger to an invitee or should have discovered the condition and its danger. 2, should have expected that the invitee would not discover or realize the danger of the condition or would fail to protect himself or herself against it. And 3, fail to use reasonable care to protect the invitee against the danger. That's in a nutshell. That's how the law applies to a situation where you're given a tanning booth and there's a danger in it. So let's go through the first element. Knew that the condition existed or should have discovered the condition. Mr. Tomich testified that in the other stores, the 5 other stores, they had newer machines or different machines with better guards. Remember, he testified that in this particular store, the guards were different than the other. These were used tanning beds. They were 14 years old. Yet he inspected them monthly in the sense that he would take down the fan to clean them and replace the bulbs. So that means that if a machine was bought in 2007, he said it was a couple years before this 2009 incident, that he would have gotten 24 careful looks at the finger-sized gaps in the fan, taking it down and putting them back up. I would suggest to you he knew of the condition or should have discovered the condition by doing all of that. Should have discovered that the condition was dangerous. It knows that it's grossly unsafe to have no guard at all on a fan. If they took those guards off, he took them off and just put no fan on it, no guard on it. It'd just be totally unsafe. Knows that getting a hand into a fan is a danger. Admits that anything that needlessly endangers is by definition unreasonable. So if you look at it in one term, if he had never put the fan guard back on there after those 24 times that he'd taken it down, just totally dangerous. But I would suggest to you putting a fan guard back up there that is inadequate and not giving any warning that it's inadequate and it's going to cause a likelihood of your fingers getting into it is equally dangerous, if not more, because it gives you the impression that it's guarded, but it's not a safe and effective guard. Should expect that the invitee will not discover or realize the danger, but would fail to protect herself against it. Now, you expect customers come in to think the guard would shield them from the fan. If you go into any kind of an environment like this, you expect that you're protected. You expect you're not going to get electrocuted. You expect that the fan is going to be guarded. Expects that customers will reach for the makeshift handles in the tanning booth. Now remember, in this particular case, the manufacturer was never contacted to get new handles. He just put makeshift handles up there. But he knew all the customers would reach up for it because they want to get an even tan. Expects customers to wear protective goggles. Expected customers to assume that the guarded fan wasn't dangerous. No need to protect yourself against a non-danger. If you are given an environment that you have a right to assume is not dangerous, and one of the instructions in here, we don't have time to go every one of them, but one of the law statements says you have a right to assume that the other person is going to do something that's not dangerous and not going to endanger you. All the time when we're down the highway, we expect that the person's going to stay on the other side of the white lines that separate. We have a right to assume that they're going to stay in their lane and not come into ours. Fails to exercise reasonable care to protect the invitee against the danger. Never contacted hex for new handles. Installed makeshift handles rather than use the hex handles. Added a simple mesh 2 to 3 days after Bonnie was injured. Pretty easy to correct it. Cost approximately $100 for the mesh, 2 hours to install it. Cedar Lakes machines were 14 years old and half price. He gave a range of the machines. If each machine cost $50,000 new, then those 3 machines that he had there saved about $75,000 on it. With $75,000 saved on a used bed, a $300 mesh, and the time to put it in would have been a great bargain. Putting a warning sign up would have been only the cost of a tape and a cardboard and the ink to put a warning sign up. Remember, he said that the fan guard only got fixed because Bonnie got hurt. He sat up here and told her if Bonnie hadn't got hurt, that guard would never be fixed. It would still be the same as it is right now, as it was then. Now, another instruction you'll get is in deciding the amount of money you consider factors like the nature and extent of the injury, the effect of the injury on a person's ability to function, whether the injury is temporary or permanent. And we'll go through. Some aspects of this injury were temporary. Some of them are permanent. Lost times and earnings, and lost impairment of earnings. Physical pain and mental suffering that she has experienced or is likely to experience in the future. Reasonable value of necessary medical care incurred or to be incurred in the future. Disfigurement and deformity and life expectancy. Bonnie Martin now is 53 years old. Her life expectancy is 29.7 years. And the nature and extent of her injuries, fingers were lacerated, broken, nail bed damaged, surgery required. Limited functioning while healing is what happened to her. She has a disfigurement and a deformity and excruciating pain. Now, we don't torture people in this nation, but you always hear about waterboarding as being a way to torture. But in some societies, they torture by pulling fingernails off. This was a very painful sort of thing. Here's how I would calculate figuring out the damages. And no matter what I say, the defense will stand up there and say, well, it's outrageous of what the plaintiffs are asking for. But I think if you look at this, her lost earnings, $3,175. She was not able to work for about 78 days. I basically calculated about $25 a day for those 78 days, for her not being able to work and also for her not being able to function in normal work, in normal non-work life. Not being able to open a tuna fish can, not being able to use both arms for that time period. Nature and extent of the injury: fingers lacerated, broken, nail bed damage, surgery. I would put in a number of $35,000. These are suggestions for you to talk about when you're back there. If somebody says, well, I want more, I think there should be more for the plaintiff for that. If somebody says there should be less, these are just guidelines for you to talk about. But remember, that surgery, and you can see the surgical notes, was a reconstruction of the nail bed, and the nail was removed and replanted and put back on there. And it was a very painful process. Disfigurement for the past 1,468 days. Can't use cosmetic nails, can't fix it. I put like a $2 a day, $2,936. Disfigurement for the future. 29 years, the same couple dollars a day for what she's gone through. Physical pain and mental suffering, that's at the $25 a day for that high level period of time for the 78 days where she was having extreme pain. Physical pain and mental suffering is at the $2 a day level for the next 29 years for what she's gone through. Now that's the feeling when it's very cold, that she's in the freezer or touching the meats and touching the different things. That's the type of pain and discomfort she's going through. The medical costs, reasonable value of those, $9,667, and we have the total that we add up here at the bottom. Where do you put these numbers? On a jury verdict form, you have a percentage for Bonnie Martin, you have a percentage of fault that you assess for fuel fitness. I would suggest to you Bonnie had nothing that she did wrong other than to trust that this company had provided her a safe place to have a tanning booth. So I would put 0 there. I would suggest to you that a company that gets a 14-year-old tanning booth, cobbles them together with makeshift handles, is not contacting the manufacturer to get the right kind of handles, is really not doing a job at all to make these things safe. And I would put 100% at fault. Remember, we changed those time after time, took them off, cleaned them, did all kinds of checking of the bulbs, at least on a monthly basis for a couple of years. You then decide the total amount of the plaintiff's damages. In this instance, the number that I had given you on the past page that should be fit in there. Then we calculate the plaintiff's verdict amount as follows, with the total damages times the defendant's fault. If you were to say, well, the defendant's 90% at fault, then you take 90% times total damages. If you say the defendant's 100% at fault, you multiply 100%. I would suggest to you that in this particular instance, if you consider what happened to Bonnie, the circumstances indicate that she did nothing wrong in this particular instance. I will have a chance to talk to you again in a few minutes, and we divide our time, and I'll have more to say about the circumstances. Thank you.
Let's see you on the cover now. Get together. There's a book of David Ball on damages. This is volume 3. And it's a book that's sold to lawyers like Mr. Holland on trick questions to use when you're examining the witness.
Objection, Your Honor. Evidence has to be argued, nothing other than evidence.